appeal in the matter of Mr Le Patourel and BT Group PLC in another.
Yes.
My Lord, I appear with Ms Love and Mr Kerrim for the appellants BT. Ms Kreisberger appears with Mr Grubeck for the respondent, the class representative.
Yes.
This is BT's appeal against the decision of the Competition Appeal Tribunal to certify collective proceedings against BT on an opt-out basis rather than an opt-in basis. In terms of the structure of my submissions, I propose to start by giving some background to the claim to the issues which arise on the appeal. Secondly, I propose to address the statutory framework, including the provisions of the Competition Act 98, the CAT rules, the CAT guide, and the relevant legislative history. Thirdly, I will address the CAT's judgment. And then fourthly, I'll make my submissions on each of the three grounds of appeal, and in that context, I will pick up the points made by the respondents.
Yeah.
Starting with the background, the class representatives claims a standalone claim, and it alleges abuse of a dominant position. The allegation is that BT imposed excessive prices for certain residential landline services known as standalone fixed voice services. The claim is brought on behalf of 2.3 million BT customers, and the class representative seeks an aggregate award of damages estimated at £589 million. The inspiration for the claim were certain provisional non-binding conclusions expressed by Ofcom in its 2017 review of the market for standalone landline services. The class representative sought to bring the claim on an opt-out basis only, and one of the key reasons advanced as to why it was said that it would be impractical to bring the proceedings on an opt-in basis was what was said to be the disengaged nature of the class. And the court can see that from the claim form. If the court takes up Core Bundle tab 7, page 135,
Yeah.
paragraph 80, there's the heading nature of the proposed class, and it said members of the proposed class have characteristics which suggest that many of them are in groups that are considered to be vulnerable, as Ofcom noted, SFV, that's standalone fixed voice customers, tended to be. And then they say elderly stroke older, point A, in lower socio-economic groups, and disengaged, point C. If the court then turns to page 173 in the same tab, this is where the class representative sets out the submissions as to why it said that the opt-in collective proceedings would not be practicable. And at paragraph 184, there are essentially 2 points made. The first one concerns the sums in question. The second one, B, cross-refers back to paragraph 80 that I've just shown you and says many of the proposed class members are generally unengaged, elderly, in lower socio-economic households, and or in the case of voice-only customers by definition do not have access to the internet. As the statement noted, it is exactly this low level of consumer engagement that has contributed to cementing BT's position in the market, leading to what the class representative contends is an abuse. For these reasons, it is said it is impracticable to expect these consumers to take proactive steps required to opt into the proposed collective proceedings.
Yeah.
And there are then some references to the class representative's evidence, which we'll come to, but you then see down at paragraph 187, the class representative recognises that it might well be possible to identify and contact proposed class members, but it's argued the major obstacle would arise after members of the proposed class have been identified and contacted, because it said individual members of the proposed class are very unlikely to take the proactive steps required to opt into a class action. If we look briefly at the class representative's witness statement, it's in the supplemental bundle, tab 1, page 8. court will see from paragraph 22 that there was no dispute at this stage that members of the class were easily identifiable. So paragraph 22 says, I believe that whether an individual falls within the proposed class or proposed subclasses is a factual question that will be straightforward for BT to confirm, either from its current or historic customer records. And at paragraph 24, you see an expressed intention to provide the proposed class members with information which is easy to understand, adopting plain and simple language to explain the legal terms and definitions to ensure that the proposed class members are aware of their legal rights. There's a cross-reference to the notice and administration plan, which we will come to. But you see the class representative saying at this stage, working with my advisors, I will, at the distribution stage, also provide clear guidance to the proposed class members on the options and steps available to them to do this. As such, proposed class members will be clearly identifiable. The court then turns to page 11. This is the section of the witness statement dealing with suitability for collective proceedings. And paragraphs 31 and 32 are the paragraphs in which the class representative sets out its case as to why they said an opt-out mechanism is the most suitable form of collective proceeding for this action. Can I ask the court just very quickly to read paragraphs 31 and 32?
Yeah.
My lords, I make 3 points about the content of these paragraphs. The first is that the obstacle which is being anticipated is not identifying and contacting these potential class members. It is having to go to the effort of seeking to persuade the class members to participate in the claim once they've been identified and contacted. And so, for example, 31B says that by claiming on an opt-out basis, we will have a more inclusive approach that covers as many proposed class members as possible without going to the very significant prohibitive extra costs and administration required under an opt-in regime to inform them about their rights to compensation and persuade them to participate. And the same point comes through very clearly from paragraph 32, where you see the view expressed that even with the most intensive efforts to notify claimants, and even if they were offered every conceivable way to register their claim, forcing members of such a disengaged and technically unconfident group to opt into a little-known process concerning a claim about technologies they don't really understand would inevitably lead to a huge dropout rate, even among those who were aware they might be due damages. So the concern is not identifying and contacting them, it's persuading them to opt in once you've done that.
Convertibility, not identifiability.
My lord, yes. My lord, secondly, virtually all the concerns identified in these paragraphs apply with equal force at the distribution stage as they do at the stage where a class member might be required to opt in. And so the reliance on the inherent disengagement of the class and the dislike of research, form filling, engaging with authority and administration, which is mentioned in paragraph 31A, the fact that they don't have internet access, which is mentioned at 31C, the individual characteristics of the class and the quantum of the amounts involved, all of those provide obstacles both at the stage when you opt in and equally at the distribution stage.
Well, they don't if you do it by way of account credit.
Well, my lord, we need to come to that because in our submission that's not open.
I know, I understand that point, but if you're wrong about that, then an account credit is a way of dealing with that issue because BT has the lists of, I mean, okay, it doesn't deal with deceased and people who might have sort of got lost somewhere, but the bulk of them would be covered from BT's records, wouldn't they?
My lord, that's certainly the way in which the tribunal sought to grapple, one of the ways in which the tribunal sought to grapple with this. The third point that I make about these paragraphs is that what is being said here about the likelihood of opting in is essentially an expression of an opinion on the part of the class representative. And the reason I say that is because although there are cross-references to Ofcom's findings on things such as class characteristics, what is being said about the likelihood that people might or might not opt in doesn't have any particular evidential basis. It's essentially an assertion being made on the part of the class representative. My lords, I showed you there was a cross-reference to the notice administration plan. That's
It may be an expression of opinion. The tribunal then has to appraise it and form its own view as to whether, even as an expression of opinion, it's rational, got legs, is something which they can consider almost as a matter of judicial notice.
My lord, that is fair. I will have some submissions to make when we come to the judgment about the extent to which that actually took place. Supplemental bundle tab 13 is the notice of administration plan. And if the court
Give me
looks,
the page number, because I'm trying to work electronically.
it's 321.
Thank you.
There's a heading distribution stage, and what comes through from this document is that the class representative themselves envisaged that at this stage BT's customer records would be used to contact and communicate with class members, and that at this stage they would be required to take proactive steps in order to make a claim. And so if we look at paragraph 129, what's envisaged is, in the event that any judgment or settlement in the proposed collective proceedings place a requirement on BT to provide details of customers falling within the definition of proposed class member, or to assist in providing notice to proposed class members, a direct noticing campaign will also be initiated at this stage, whereby proposed class members are directly provided with, via their preferred contact method according to BT records, or copy of the claim form. And then if we go over the page to page 322, there are sections dealing with what is envisaged to happen at the point where the proposed class member files a claim. And paragraph 134 says, in the event of an aggregate award of damages being made, or a collective settlement approved, a claim form and claims process will be made available for all proposed class members that will have not opted out. The claim procedure will take place online, by post and by telephone. So at this stage, by the distribution stage, the class representative themselves were envisaging that there would have to be a process of positive action and engagement on behalf of the class members in order to make a claim. In BT's response to the collective proceedings, BT first of all sought summary judgment or strikeout of the claim. And BT also made 2 points which are important from the perspective of the opt-in, opt-out question. The first was that BT adduced evidence which confirmed that class members could be identified and contacted. And that's in the witness statement of Mr Bunt, who is the Director of Regulatory Affairs for BT Consumer. This is Supplemental Bundle tab 2, page 34. The passage we're concerned with actually starts from page 36, paragraph 14. Mr Bunt explains partway through the paragraph, BT is able to identify all customers who will be eligible members of the proposed class based on the data BT routinely holds for current and former customers. For reasons outlined in more detail below, BT will be able to use the data in the billing database to contact all existing customers and most former customers within the proposed class, save for those who have both moved address since they left BT and also changed their telephone number. And he explains at 16, BT holds in a database customer records for billing purposes, which in the context of SFV customers would include customer name, billing address, email address, landline number, mobile number. Paragraph 19, partway down, explains upon termination, BT retains the former customer's last known billing address and, if provided, its mobile number in the BT database. The court turns over the page to paragraph 20. Mr Bunt says, in my experience, most of BT's standalone fixed voice customers who terminate their contract with BT and move to another provider, whether because they have moved address or otherwise, also port their landline telephone number, meaning they would have the same telephone number as they did when they were a BT customer, would remain on BT's records, and And he says, likewise, customers often port their mobile numbers. And so, by way of conclusion of paragraph 22, you can see that BT will be able to communicate with current customers within the class in the same way as it communicates with them for billing and marketing purposes. And he says, as for former customers, I would expect that most of them could also be contacted using the last known billing address and or their landline or mobile numbers. As the court will appreciate, this is an exceptional feature of these particular claims, and it takes them out of the realm of a normal cartel consumer claim, where you might not be able to identify any particular consumer that had purchased the products in question. And even if you can identify them, you might not be able to find contact details in order to approach them and try and persuade them to opt in a claim. And this is the distinction which underpins ground one of BT's appeal. Secondly, in its response, BT made the point that there was an inconsistency in the class representative's approach. And the inconsistency arises because if the disengagement of class members was so great that they can't be persuaded to opt in, then equally it would not be possible to distribute any damages award to them. And in that circumstance, the collective proceedings become merely a vehicle for lawyers and funders. And that would be a cause for real concern. And it might potentially be a reason why the proceedings would not be suitable for collective proceedings. But if, on the other hand, as the class representative contended, class members can be identified and they can be contacted and they can be assisted to fill in a claim form at the distribution stage, then there's no reason why it would not be practicable for them to opt in at the outset of the proceedings. That was in our submission, quite fundamental discrepancy in the class representative's approach. And it was in response to BT identifying that issue that the class representative made the suggestion for the first time in its skeleton argument that distribution could be achieved without any proactive steps being taken by the class member by the mechanism of crediting their account. And that's in the court's record. It's supplemental bundle, tab 4, page 76. The court will see there the submission. Distribution in this case will be straightforward and can be achieved without any steps being taken by the class member. And indeed, at paragraph 33, you see the class representative citing BT's evidence from Mr Bunt and relying on it. So they say Mr Bunt stresses that BT is able to identify all customers who will be eligible members of the proposed class based on the data BT routinely holds for current and former customers. Accordingly, while the litigation notice and administration plans will ensure that class members are made aware of the claims and their rights to collect their share of the award, existing customers could be automatically compensated by BT so that concerns as to a large unclaimed fund do not arise. In short, since this is a case brought against a single undertaking with the averred ability to contact class members, it is a paradigm of a CPO in which distribution should present little difficulty. So at that stage, the class representative was positively relying on BT's evidence that it could contact class members. I emphasise that because it is somewhat inconsistent with the position taken by the class representative in their skeleton before this court, where they say that the ability to contact class members is not the panacea presented by BT.
It does seem that there's something of a difference, isn't there, between contacting people of this group to say, would you like to form part of a class action to bring proceedings against BT, and contacting them to say, you may well be entitled to a share of a pot of money by way of compensation, which doesn't, on the face of it, require them to join in legal proceedings. And a lot of people, no matter what reassurance, will be concerned if they join in legal proceedings, it will involve all sorts of obligations. It seems to me to be two quite different prospects.
Well, my lord, that's the submission that's made against me. I do say that when one looks at, in particular, the legislative history, one can see that the fact that there might be a difference between the number of people who opt in at the outset and the number of people opt in at the end cannot be the answer for the purpose of practicability, the test of practicability under the statute. Because it's likely always to be the case that you can say, oh, well, people are more likely to sign up if they think it's guaranteed money. and less likely to sign up at the outset. But then nevertheless, we have a statutory regime which envisages that in some cases an opt-in procedure will nevertheless be appropriate. And the example that's given in that context is one where you can identify and contact the class members.
But forgive me, all we're talking about here, as I understand it, is you're saying effectively there's an inconsistency in their approach. And I'm not sure that, what I'm putting to you is I'm not sure it is necessarily inconsistent.
My Lord, it is in my submission, it's a difficulty for the class representative in the sense that either class members can be expected to take positive steps, in which case they can be expected to opt in, or they can't, in which case they won't even do it at the distribution
But they
stage.
take into account that the positive steps may be different.
Well, my Lord, they're not different in the sense that I've shown your Lordship the
That's the point
distribution
that my
plan.
lord just made to you, which is that there's a world of difference between saying to somebody, would you like to join a class action, they will immediately think, gosh, I might be responsible for legal costs, especially elderly people like this. The world of difference between that and saying we've recovered X in a class action, you are entitled to your share of X, which may only be 140 quid or whatever it is. But there's no strings attached, which effectively would be what they would be saying. And it seems to me, as a matter of common sense, there's a difference between those two, even if we didn't have Lord Legate telling us that there is.
My Lord, if that difference were material, for the purposes of determining whether or not something is practicable, which is the statutory test, then you would never have an opt-in claim. Something would never be determined to be practical.
We're dealing with particular types of people. Wouldn't necessarily apply in every case.
I mean, this is a very big class. If you had a much smaller class of more sophisticated customers, that might be a factor in favour of an opt-in. When you've got a very, very large class and a relatively modest award, as I think both the Supreme Court in Merricks and Lloyd was suggesting, that might favour opt-out. I mean, that I understand is, I think you said, might emasculate the system if you just simply took those two factors. But I mean, that might just be the way the dynamics of these claims work.
Certainly, my Lord, the size of the class is another factor that's identified in the materials as might be indicative of relevant to the decision whether you opt in or opt out. But it is a distinct factor from the factor of the contactability of the class members. That is identified as a factor independently. And I will be making the submission that if the answer to that question is simply to say, oh, well, people are more likely to opt in once they know they've got a sum of money, then that is going to be inconsistent with the principles which underlie the statutory regime.
Do you say that convertibility is an irrelevant factor? Let's assume in the case of identifiability and contactability, they're givens, which may be the case here. In law, is convertibility irrelevant?
I will be making the submission based on the recent judgment in the McLaren case that it is not relevant to ask if you can identify and contact your class members. The efforts you have to make to try and persuade them to opt in are not relevant to whether opt-in is practical or impractical. And I'll show your Lordship the recent judgment which makes that point. What's said in this case is,
Sorry,
well,
what
this
judgment is
particular
that?
class, it's the McLaren judgment, I'll take your Lordship to it.
Okay.
It's said in this case, well, this particular class have particular characteristics which mean that they're much less likely to opt in than anyone else. But this is where I rely on the fact that nevertheless they're being expected to do so at the distribution stage. My Lords, I'm moving on to deal with the statutory framework. Starting off in Authorities Bundle, tab 1, page 5. Your Lordship should have there section 47A, which is the provision which permits claims to be made in proceedings before the Competition Appeal Tribunal. And the present claim is a claim in respect of an alleged infringement of the Chapter 2 prohibition, so it falls under section 47A, subsection 2, subsection B. And then over the page you have subsection 3, which identify the claims to which the section applies, and they are a claim for damages, any other claim for a sum of money, and in proceedings in England and Wales or Northern Ireland, a claim for an injunction. Lower down the page on 46, you've got 47B, sorry, page 6, you've got 47B, which is collective proceedings before the tribunal. And collective proceedings are defined in subparagraph 1 as proceedings combining two or more claims to which section 47A applies. Over the page, subsection 4 tells us that collective proceedings may be continued only if the tribunal makes a collective proceedings order. Subparagraph 7 tells us a collective proceedings order must include the following matters, and at C, specification of the proceedings as opt-in collective proceedings or opt-out collective proceedings. And then those concepts are defined in subparagraph 10, opt-in collective proceedings are collective proceedings which are brought on behalf of each class member who opts in by notifying the representative in a manner and by a time specified that the claim should be included in the collective proceedings. And then opt-out collective proceedings in subparagraph 11 are collective proceedings which are brought on behalf of each class member except A is any class member who opts out, and B concerns class members not domiciled in the United Kingdom at the relevant time. So those are the definitions of the concepts. If we turn over to page 8, section 47C is the provision which concerns the award of collective damages, or the award of damages in collective proceedings. And subsection 2 is the provision which entitles the tribunal to make an aggregate award of damages without undertaking an assessment of the amount of damages recoverable in respect of the claim of each represented person. If we look at subsection 3, this is concerned with opt-out proceedings, and it contains a duty on the part of the tribunal, indicated by the word must. So it says where the tribunal makes an award of damages in opt-out collective proceedings, the tribunal must make an order providing for the damages to be paid on behalf of the represented persons. And there are two possibilities: A, to the representative, or B, such person other than a represented person as the tribunal thinks fit. So that is an express duty on the part of the tribunal for opt-out proceedings. That can be then contrasted with subparagraph 4, which concerns opt-in proceedings and is permissive in its language. So it says the tribunal may make an order as described in subsection 3. So there's, in my submission, quite a careful distinction between opt-out proceedings where you have an obligation and opt-in proceedings where there is a broader discretion as to the way in which you conduct your distribution of damages.
But the rationale for that is what you say, that because in opt-out proceedings you don't necessarily have an identifiable group of people to whom the payment will be made.
That's potentially true, yes, although of course we do.
Yeah, because you haven't. People have opted in, then they've been, by definition, have been identified at the outset of the proceedings. Whereas in opt-out, they won't necessarily have been identified. I mean, so happens here they could have been identified, but if they haven't been identified, then that presents potentially a practical problem.
My lord, that's entirely correct. I can come on to show you in a second the notes to the Consumer Rights Act which tell you about the rationale for this, and what it shows you is that even in the circumstance of an opt-in proceeding, where you will, as your lordship says, have identified claimants from the outset, the court still exercises a control over the circumstances in which an individual can enforce a payment directly to them. I'll show your lordship that, but I just wanted to highlight before we do subparagraphs 5 and 6 in this section.
Just to take that one step further, if there's no aggregate award of damages, then the tribunal can make a direct order in favour of an opt-in claimant in a fixed sum. If it's an opt-in but an aggregate sum of damages, then it's more likely you would exercise the discretion to hand the sum over to the representatives because there's a more complicated process of distribution. So that's presumably why they have the discretion. You need a greater discretion for an opt-in than you do for an opt-out.
My lord, that may well be right, but we do see quite a careful statutory scheme whereby the tribunal simply does not have the option to make a direct payment in the context of an opt-out claim.
I don't at the moment see, I don't see what other option there would be than to pay it to or at the direction of the representative.
I'm sorry, my lord, I didn't hear.
I don't understand at the moment what other option there would be other than to pay it to or at the direction of the representative.
In the context of an opt-out
Yes.
claim? Well,
Well, you can see that in the context of opt-in, it might be possible to do it in another way, which is presumably why the court's given the discretion, or the cat's given the discretion. Although I suspect that in a lot of cases they would follow the same course.
of course, what's being said by the tribunal in this case is that the other option open to it is to make a direct payment by means of an account credit.
But why,
No,
forgive me,
it's not,
there's-
it's not, it's still, the way in which it would work would be the damages, the aggregate damages would be paid either to the, to the class representative or, as a matter of law at least, paid to BT. It may be by way of a set-off in the sense that they wouldn't actually pay it, they'd retain it, but they would have the damages as a matter of law. And then what's done with it is not to do with the award of, with sections 47, 3 and 4. It's to do with practical distribution thereafter. I mean, that's the argument against you.
My lord, it
that
is,
the
yes.
tribunal have accepted. And obviously one of the issues for us is whether that's permissible or not.
My lord, yes. My submission
You
would
say
be...
not permissible by
Indeed.
reference to these sections, and I think what will be said against you is that's putting it colloquially beside the point. Anyway.
Well, your lordship knows where the lines are drawn,
Yeah,
and I will develop my submissions in support of that.
I'm not saying I'm deciding where the line is, I'm simply identifying where the line is. Is there anything else in the section?
I was just going to draw attention to subparagraphs 5 and 6. Subsection 5 indicates that any damages not claimed by the represented persons must be paid to a charity, and then the exception is in subparagraph 6, which is that the tribunal may direct that unclaimed damages be paid to the representative in respect of their costs of proceedings. So I said I was going to take you to the section which indicates some of the rationale behind this. It's in tab 3 of this bundle, page 16. And this is paragraph 6 of Schedule 4 to the Enterprise Act 2002 after it was amended by the Consumer Rights Act 2015. And it's concerned with a decision of the tribunal in proceedings under section 47B of the 98 Act, so a decision in collective proceedings, which A, awards damages to a person in respect of a claim made or continued on behalf of that person, but is not the subject of an order under section 47C3 or 4 of that Act. So by definition, we know that that must be an award of damages in opt-in proceedings because that option is not open to the tribunal in relation to opt-out proceedings. It must make an order under opt-out proceedings. We saw that. And where in opt-in proceedings the tribunal directs payment directly to the represented person, it may only be enforced by the person concerned with the permission of the High Court or the Court of Session. So even such a direction in opt-in proceedings is closely controlled. And if we go over to tab 4, page 18, these are the explanatory notes of the Consumer Rights Act, and paragraph 440 on this page explains the provision that I've just shown you. What it says is, it provides that where damages are awarded in a collective action to a person who is not a party to the order, either they're not the representative or another person who the court considers are suitable to hold the damages and then distribute, and then it refers to the option B possibility, it may only be enforced if permission is granted by the High Court or the Court of Session. This is to provide some judicial control over the volume of enforcement claims being made by persons who are not the representative or other person who the CAT considers is suitable to hold the damages. So in my submission, what one sees there is a very tight rein being exerted by the legislative scheme over direct payments to individuals. You can't do it at all in opt-out proceedings, and even if you do it in opt-in proceedings, you have to have permission to enforce it. Moving on to the CAT
Can I just ask you
rules.
about costs, something which I'm just trying to make sure I understand. The CAT has, in relation to collective actions in a number of different parts of the rules, a very broad case management power. Is there any difficulty in the CAT making an appropriate order for costs to ensure that the class representatives and any experts and so on are paid before distribution phase? I mean, can the CAT not make an order, X is to be paid to the legal representatives, costs are to be deducted, then distribution is to occur?
Well, sir, my lord, I'm sorry. The statutory provision in 47C that we just looked at envisages that the costs will happen afterwards. So
After distribution.
after distribution out of the unclaimed sum.
That's
So
in relation to unallocated funds, so funds which would otherwise go to charity.
my lord, yes.
So that's a particular provision related to costs. Is there anything more general which would prevent the CAT ensuring that in opt-out proceedings, the funders and the legal representatives and so on are paid? They have a very broad case management power. I'm just wondering if it would be a bit odd if they couldn't make sensible provision for costs when funding is one of the considerations which are taken into account in deciding whether to order an opt-in or an opt-out. Is there anything which prevents them just making whatever order they wish as to costs, save insofar as we're dealing with unallocated funds and ensuring that the proper amount goes to charity and not the funds?
Well, my lord, I hesitate to give an answer on my feet to that because it's not a matter that I've particularly turned my mind to for the purposes of this hearing. But insofar as
We'll come back to it. There's a flurry going on
Indeed.
behind you. So we'll let the flurry continue.
the productive flurry might generate an answer,
Yeah.
I hope.
Yeah.
In the meantime,
Just so the flurry is understanding where the thought process. One wouldn't want to arrive at a situation whereby there was some artificial rule constraining the award of costs to funders, representatives of experts and so on. If that then had a perverse operation on the effect of the decision about opt-in or opt-out. I mean, I'd rather assume the tribunal has very, very broad case management powers, including as to costs. And the provision you've identified was really to protect the charity from an exaggerated claim for costs, rather than really providing the only way in which the tribunal can manage costs.
my lord, yes, I'm certainly not making a submission about the limited scope of an ability to make an award of cost. The reliance I place on the provisions that I've just identified relates to the jurisdiction of the tribunal to make a direct payment to a member of the represented class.
Yes.
And just to foreshadow what I propose to say, it's that those provisions envisage an active claim being made by
Yes.
the members of the class.
Yes.
And that my submission will be that that is in tension with any.
I mean, is the practical reality, going back to paragraph 440 of the notes to the Consumer Rights Act, that the judicial control that's envisaged is really seeking to encourage the CAT to approach section 47C questions really by paying to the class representative or to some other nominated person or body, as opposed to leaving it as a free-for-all in all the opt-in proceedings, because that's what this has got in mind, isn't it? That you haven't made an order to that effect, so it's then sort of that, you know, let's assume it's not too big a class. It's 150 people, all 150 of them clambering on and saying, I want my share, and the court has to be approved by the court. But if I'm in the position of the CAT deciding what it's going to do, looking at that, if it were me, I'd be saying, well, in that case, the best order to make is to order it paid to the class representative and let him or her sort it out thereafter.
My lord, it certainly suggests that there is a reticence to permit direct payments to individuals, even where there is a nominal discretion
That's what I.
to do so. My Lord, in response to your Lordship's question about costs, Rule 104 in the CAT rules, which I don't think is in the authorities, that's the broad discretion on the tribunal in respect of costs. But it's certainly not part of my submission to suggest that there's a constraint on the ability to deal with costs.
Yes, that's in part 6, and part 6 applies under Rule 3A to collective proceedings.
My Lord, yes.
Those costs won't necessarily be out of the damages, they may be separate costs.
Certainly, having a broad discretion would suggest that that is a possibility, yes. I was moving on to show your Lordships the relevant provisions of the CAT rules, and they are in Authorities tab 6, starting at page 67. And we have here Rule 79, which is the provision which concerned with the certification of claims as eligible for inclusion in collective proceedings. And Rule 79.1 sets out a 3-limb test. Are claims brought on behalf of an identifiable class of persons? Do they raise common issues, and are they suitable to be brought in collective proceedings? And Rule 79.2 then concerns the test for suitability, and it provides that the tribunal may take into account all matters it thinks fit, including the specific matters enumerated in paragraphs A to G. And it's this test of suitability that was the subject of consideration by this court and the Supreme Court in Merricks. This case is not concerned with the suitability criterion, it's concerned with the provision in subparagraph 3 about whether proceedings should be opt-in or opt-out. And that provides that the tribunal may take into account all matters it thinks fit, including the following matters additional to those set out in paragraph 2. So 2 further additional matters identified, being A, the strength of the claims, and B, whether it is practicable for the proceedings to be brought as opt-in collective proceedings, having regard to all the circumstances, including the estimated amount of the damages that individual class members may recover. So that is the practicability test that has to be applied. Turning to Rule 93, which concerns distribution, that reflects the mandatory wording that we've seen in section 42C of the Act. So, 47C. So where the tribunal makes an award of damages in opt-out collective proceedings, it shall make an order providing for the damages to be paid on behalf of the represented persons to either A, the class representative, or B, such person other than a represented person as the tribunal thinks fit. And then equally consistently with the Act, you then have subparagraph 2, which is where you're dealing with opt-in proceedings. It may make an order as described in paragraph 1. Rule 93.3 then concerns the content of any such order. And what it contemplates very clearly in my submission is that the represented persons will claim their entitlement. They shall actively claim their entitlement to a share of the aggregate award. So we see in A that the order may specify the date by which the represented persons shall claim their entitlement, and then under B, the date by which the class representative or person specified in accordance with paragraph 1B will notify the tribunal of any undistributed damages which have not been claimed. Again, there's a contemplation that there'll be an active claim. And then Rule 93.4 to 6 concern what the tribunal can then do with unclaimed damages, and we've seen consistent with the Act, they can either be put towards the class representative's costs or they can be paid to the designated charity.
Is it still justice? That's the...
It is, I think, yes. Turning to the CAT guide, which is in tab 5 of the bundle, The guide has the status of a practice direction, and it was issued by the president. I'm sorry, page number. It begins at page 38. It was issued by the President of the Competition Appeal Tribunal pursuant to Rule 115 of the CAT rules. And page 38 should have there paragraph 6.39, which is the paragraph which is dealing with whether proceedings should be opt-in or opt-out.
Just in relation to this, it does seem to me that possibly one section of this which is relevant, which is not in the bundle, is the preface.
My lord, yes, it is. The content of the preface is cited in our skeleton argument. I'm conscious that I don't think it is in the bundle. We can provide it separately if it would be of assistance.
I think it's quite important context to the section on collective proceedings. It rather deliberately waters down the status and effect of anything said in the section on collective proceedings by recognition that it's all very novel, there's no judicial experience, that it all might change, and that the tribunal will have to take account of evolving thinking about collective proceedings. So I know you rely on some of the provisions in relation to collective proceedings, but in terms of the weight that the tribunal itself, or we have to attach to that part, we have to look at what the tribunal itself says about that part in the preface.
My lord, yes. I do say, when I come to deal with the legislative history, I do say that the parts that I rely on in the guide, the origin of them can be traced through to some of the principles that you see coming through from the legislative history. So there is in my submission, there is some force to be accorded to these things because they reflect the thought process of the legislature. Your lordships will see that this paragraph is identifying the two specific factors that were identified in Rule 79.3. And under the strength of the claims, you see the guide making 5 points. First, it recognises that opt-out proceedings entail greater complexity, costs and risks in comparison to opt-in proceedings. Secondly, you will see that the tribunal will usually expect the strength of the claims to be more immediately perceptible in an opt-out as compared to an opt-in case. Thirdly, it makes the point that in an opt-in case, the class members have chosen to be part of the proceedings and may be presumed to have conducted their own assessment of the strength of their claim. Fourthly, you see the guide explaining the nature of the merits assessment that the tribunal must conduct. So it explains that the reference to the strength of the claims test doesn't require the tribunal to conduct a full merits assessment. The tribunal does not expect the parties to make detailed submissions as if that were the case. Rather, the tribunal will form a high-level view of the strength of the claims based on the collective proceedings claim form. And then fifthly, where the claims seek damages for the consequence of an infringement which is covered by a decision of a competition authority, so essentially a follow-on claim, the guide says that would generally be of sufficient strength for these purposes. And under the second head in this paragraph...
Can I just ask you about that? I mean, that's rather a weak statement for a follow-on. If it binds the tribunal as to liability so that all you're then left with is quantum and distribution, that would be a matter which is relevant to the simplicity and complexity of the litigation, presumably.
Absolutely, my lord, yes, yes. We do make a point in relation to this because we say that this is giving you an indication of the sort of claim which is considered will generally be of sufficient strength. And as your lordship says, a follow-on claim is one in which there is no dispute as to liability. So that's actually a relatively an indication of a strong claim satisfying the text. It doesn't provide any support for a weak merits test.
No.
Under what's practicable, you see the guide making a further 3 points. First, the tribunal will consider all the circumstances, including the estimated amount of damages that individual class members may recover, in determining whether it's practical for the proceedings to be opt-in. Secondly, you see that there is a general preference for proceedings to be opt-in, where practicable. And thirdly, you see the guide identifying 2 indicators that an opt-in approach could be both workable and in the interests of justice. I do draw attention to that strong wording there. It's not just workable, it's in the interests of justice to take an opt-in approach where it's practicable. And the two indicators are the fact that the class is small but the loss suffered by each class member is high, or, obviously or indicates that these are in the alternative rather than cumulative, the fact that it's straightforward to identify and contact the class members.
It doesn't refer at all to convertibility.
My lord, it doesn't, which in some respects I would submit is a point in my favour, in the sense that this guide is saying the fact that it's straightforward to identify and contact the class members is an indicator that an opt-in would be appropriate, without any sort of caveat to say, well, you need to satisfy yourself that you can persuade them to opt in. Turning to page 45.
Well, isn't the first, I mean, on one view, the first sentence is where it says the tribunal will consider all the circumstances, including the estimated amount of damages individual class members may recover, in determining whether it's practical for the proceeding to be certified as opt-in. I mean, that is, isn't it, looking at least potentially at convertibility. In other words, where it's a large class and they're all going to recover as thrums halfpenny, it's not practicable to have an opt-in arrangement because for all the reasons that the tribunal gave here and that the Supreme Court has given in the Google and Lloyd case.
Well, I'm going to come on to address the Google and Lloyd case, and our submission will be that it's not as much of an assistance as is submitted by the class representative.
Well, that may be right, but the overall point that's being made is that if you, which is made here, is if you've got a class of people lower down the socio-economic scale than people who have bundles from BT with internet bundles and so forth, which probably most of us have got. So you're dealing with people who, a lot of whom only have a telephone and don't have a mobile phone. They're all, say all, nearly all of them are fairly elderly, said to be vulnerable. You can quite see why, if all they're going to get at the end of the day is £140, it could be said, because that's the size of their likely recoverable damages, it's not practicable for them to be part of an opt-in arrangement as opposed to an opt-out arrangement.
Well, my lord, when we come to
Otherwise, what's the point of referring to the estimated amount of damages? What's the relevance of that to practicability, if this isn't to do with what my lord's described as convertibility?
one can certainly see that indirectly one might reason that if the amount of the damages is small, then you might struggle to persuade someone to participate. That is, in my submission, a somewhat indirect allusion, and it doesn't, in my submission, undermine the point that where you see mention of an indicator that opt-in is both workable and in the interest of justice, what is mentioned is not convertibility, but contact.
Well, the converse of the factors are that suggest that if the class is large and the loss suffered by the members is low, that would suggest that it's not workable and not in the interest of justice.
Well, my lord, this is why I emphasise that these are not cumulative requirements, because your lordship is focusing on the first indicator and reversing it. But there are two potential indicators, and the second one does point in favour of opt-in, and so the fact that you reverse the first one in my submission doesn't necessarily mean that you automatically conclude that this is not suitable for...
No, I don't think anyone's suggesting anything's automatic here, are they? Because it's all the circumstances.
My lord, yes.
And things might indicate. They're all just factors, aren't they? It's a
My lord, that's entirely fair,
multifactorial
yes.
approach.
It is a multifactorial approach.
Yes.
The submission I make is that these are independent factors, and therefore the guide is indicating that the fact that it is straightforward to identify and contact the class members is capable, independently, of supplying an indicator that opt-in is appropriate and in the interest of justice.
It much harder for you to submit that the tribunal was overall.
Well, my lord, we can look at the reasoning of the tribunal. One doesn't see a lot of reference to the estimated amount of the damages being low. And I will have some submissions to make about the extent of the reasoning of the tribunal.
I mean, it's common ground that they're between a range of, was it 150 and 400 odd? You know, it's in the claim. I don't think there's any dispute as to the the total sum, including interest and what have you, is over 500 million, 2.3 million potential claimants, on average, quick maths, 250 quid a piece.
Yeah.
But there is a range, I think, set out in the claim from about 140 up to 300. So we know the scale. There's no real dispute about the scale of highs and lows of the damages. So call it 200, 250. I mean, if I come to you after the event and say, Ms. Ford, I'm from BT, I've got 250 quid for you, will you give me your bank account details? I suspect you might exercise a degree of scepticism.
My lord, just before I move on to respond to that specific question, I should say I don't think we have committed ourselves either way as the likely amount of damage that will be recoverable. We certainly don't dispute that they're likely to be modest. I think that much is common ground. Although
Let's just assume for the purposes of the argument that the figures given are approximately right. I mean, the law's right that if you divide 589 million by 2.3 million, you get to something about 250, I think. So let's assume it's £250. And says, you know, you suddenly get a phone call on your landline, as you would do in this instance, out of the blue, saying, yeah, I've got £250 for you.
Give me your bank details.
Give me your bank account details.
Well, your lordship's point is an interesting one because, of course, this is the proposition that the class representative is advancing at the distribution stage, and it said that that is going to be sufficient to persuade people to participate at that stage. And our submission
Absent
is
an account credit.
Well, that's a,
absent an account
yeah,
credit, indeed.
that's why they say the practical way out of this is the account credit.
I know they do, and they need to, in the sense that, in my submission, it's quite telling that the steps that these people are being invited to make at the distribution stage are essentially indistinguishable from what they would have to do to opt in.
But I think, my lord, at least I'm making a different point, I think we both are, which is that you can see that where the, if you like, the fault lines lie in the argument that says, well, it's absolutely all right to have opt-in on this, and it's absolutely all right to have distribution by ringing people up and saying, I've got 250 quid for you, give me your bank account details. Because the reality is, even if you ignore the fact that they're elderly people and vulnerable and so forth, most people receiving a phone call like that would think it was a scam.
My lord, in my
So
submission,
you
that,
can see practical difficulties, that's the point that I'm making.
indeed, at both stages,
Yeah.
and that is a problem in my submission.
Presumably there'll be a letter written to
Or a
them.
letter, yes. Same point though, isn't it? You know.
Well, I showed your lordship the section of the distribution plan where it's envisaged that BT's records will be used to contact people and to encourage them to fill in a claim form. And your lordship has the submission that if that can be expected of this class, then that can be done at the outset as opposed to at the distribution stage. There's no material difference between inviting them to do that.
Well, so forgive me, I know I made this point before, but I think there's a huge difference between saying to somebody, would you like to take part in proceedings against one of the largest companies in the country who's resisting them with the possibility of winning between £100 and £400, and saying to somebody, it's been determined that you're entitled to between £100 and £400 or whatever sum it is, and to receive it, you just need to fill in this form. I think there's all the difference in the world between those two propositions.
My lord, my submission will be that if that were correct as a proposition, then it would undermine the case for opt-in generally in circumstances in which the statutory regime...
You're talking about 2.3 million people, just by natural law of inertia. You know that of the 2.3 million, a very large proportion won't get round to responding, even if they would, ideal would like to. They just won't do it, and you know that there will be a huge dropout just from the way life works. And why, if this is going to end up with effectively a remediation exercise, if the claim is successful, isn't it? Is all customers will be all these customers will be entitled to credit of a few £100. Why should it end up in a position that the few 100,000 you get round to reply and get the credit their account, whereas the others don't. What's the justice? What's the interest of justice in that?
My lord, what your lordship is describing is circumstances of which the legislature were aware at the point when they introduced the regime, and they nevertheless retained the possibility of having opt-in proceedings, including in the circumstances indicated where you can contact and persuade people to participate. And therefore, in my submission, a blanket objection of that nature cannot be a reason to favour opt-in over opt-out. Opt-out over opt-in.
Well, it plainly is relevant that it's a large class with small value. It's undoubtedly a relevant factor.
My lord, yes.
And it could be viewed that was the overwhelming factor.
Well, that is not the tribunal's reasoning in this case, and we'll come on to see.
If you had a small class and the amount suffered by each class member is high, I mean, it may be a complete generalisation, but that sort of scenario is more likely to be a more sophisticated class than this class, and therefore more likely to be people who are prepared to make a decision for themselves about whether or not they opt in. And equally, if what they know they're going to get at the end of the day is £100,000 or £500,000 or whatever it is, they're more likely to opt in. So you can see. I mean, you are absolutely right that it says the general preference for proceedings to be opt in where practical. But I just wonder whether the experience that has built up over the intervening 7 years would lead to that sentence being put in the guide now.
Well, my lord, my submission would be that that sentence comes from the clear policy judgments that have been made in the legislative history, which we will come to, and isn't something which would necessarily have been displaced.
Well, the legislature doesn't say, does it? I mean, nowhere in the acts that you've shown us does it say that opt-in is, there's a general preference for opt-in.
Your lordship is right that those words don't appear. In my submission, they do come through very clearly from the factor that the tribunal is invited to consider. Is opt-in practicable? That is one of the key factors that the rules identify that the tribunal may take into account. And what it's saying there in my submission is implicitly, if it's practicable, then you should certify as opt-in. So it is a preference in favour of opt-in.
But if the reality is that experience has demonstrated that in these types of action, it isn't practical. I'm simply making the point that it may be that sentence would be put in a more guarded way. I mean, we're not entitled to say, there it is, and we've got to take it into account, and the tribunal has to take it into account, and so forth. But I'm just looking at it really in terms of these sorts of claims.
I've got another question about the guide. Sorry, we're bombarding you, but as I read section 47C and rule 79, the legislative intent is neutral as between opt-in and opt-out. There's no clear predisposition one way or another. The legislator says all circumstances, and here's some which may or may not guide you. It's only when you get to the guide that there is any form of preference expressed, albeit guarded. Can the President in a guide take a stance which is inconsistent with the legislative intent?
Well, my lord, I don't accept the premise which is behind your question, which is that that stance is inconsistent with the legislative intent, and I will show your lordship why. But I do maintain that it's not completely neutral. The rules in particular are not completely neutral, because Rule 79(3)(b) is asking whether it's practicable for the proceedings to be brought as opt-in. It's not asking in a neutral and unweighted way which is more appropriate. It's saying consider whether it is practicable for these proceedings to be brought as opt-in. And that, in my submission, does provide support. And I'll show your lordship that that derives also from some of the things that were being said in the run-up to the scheme.
So 3 itself makes the point that the tribunal may take into account all matters it thinks fit. Those include the matters additional to those in 2, which relate to suitability. And in relation to suitability, again, the tribunal takes account of all matters that it sees fit. So the starting point is all matters, and the rules then say, well, there may be some indicia which you can, if you think it's appropriate, take into account. I'm not certain why that's not just the a priori starting point is one of neutrality, with a variety of factors which might swing either way. There's no clear disposition in favour of one or t'other.
I certainly do not dissent from the fact that there is a multifactorial test, as it's been described, and that there are various factors that can be taken into account. In my submission, when you look at the factors which are specifically identified as being particularly relevant to opt-in or opt-out, the way in which it's phrased, rather than simply asking you which is more appropriate, the way in which it's phrased, where the tribunal is invited to consider, is it practicable for the proceedings to be brought as opt-in, in my submission does lend support to a preference for opt-in where practicable.
I'm not sure I understand that. In that respect. I mean, I can see what the guide says, but the point my Lord's putting to you is if we look at 3B, whether it's practical for the proceedings to be brought as opt-in, having regard to all the circumstances. So they're looking at absolutely everything in order to decide whether it's practical.
My Lord, yes.
Nothing in that says there's a preference for opt-in.
I certainly don't dispute that one may take into account everything that is relevant, but in my submission that doesn't tell you that there is no preference in circumstances where the very question that's being asked is it practicable for opt-in? It's not saying which is preferable, opt-in or opt-out. It's saying, is it practicable to do this on an opt-in basis? And that is a weighted question in my submission. My Lords, I was about to show you just what the guide says about distribution, and that's Authorities tab 5, page 45, paragraph 684 to 686. And what one sees there is, once again, there's the division that we've already seen in the Act and in the rules between opt-out proceedings and opt-in proceedings, and in the former, the tribunal has a duty, and in the latter, the tribunal has more discretion. And in particular, if we look at 6.84, in opt-out proceedings, the tribunal is required to order that any damages be paid to the class representative or another person the tribunal thinks fit. In opt-in proceedings, the tribunal may make such an order, although it has a wider discretion as regards who the damages are paid to. The tribunal may, for example, order that the damages be paid directly to the represented persons. So a payment direct to the represented persons is given as an example of what may be done under the wider discretion under opt-in, but it's not open to the tribunal in opt-out proceedings. And then paragraph 6.85 is envisaging, as we saw in the Act and the rules, that the represented persons will actively claim their entitlement. And so we see that where the tribunal does make an order, it must also specify a time within which individual represented persons may claim their entitlement.
Is that a may or a must? I'm just looking back to Rule 93. Is it
Your Lordship's right that there is a distinction between the wording in the rules, which says may, and the wording of the guide, which says must.
So the rules must take precedence there.
My Lord, that's absolutely right, but it's not material for the purposes of the point that I seek to draw out of it, which is simply that what's contemplated here is an active claim. It's contemplated that, and that's this structure is facilitating an active claim by saying, well, you must claim by this date. if you don't claim by this date, we will notify the tribunal, and the tribunal can then make disposition of the undistributed damages. But certainly that the structure is envisaging active claims by the participants. Turning to deal with the legislative history, which both parties to the appeal have made reference to. If we start in the supplemental bundle, tab 6, and I find the page number. Start at page.
What are we looking at now, Ms.
This is
Lloyd?
the legislative history, which predates the Consumer Rights Act.
Thank you very much.
So starting at page 110 in tab 6, this is the Civil Justice Council report, Improving Access to Justice Through Collective Actions, dated November 2008. And if we turn to page 118 within this tab, the court will see what's being consulted on here, or what's being advocated here in this report is a generic opt-out collective action, so one which applies to all claims, not just competition claims. You can see that from the heading Private Enforcement, the case for generic opt-out collective actions. If we turn on to page 121, there's a heading Defects in the Present Collective Mechanism, and what the authors of this report do is that they work through representative actions under the CPR. If you go to page 123, they address test cases, joinder and consolidation. Page 126, they address GLOs, and page 129 then deals with the new consumer mechanism. And at paragraph 22, you see a refrain which features in a lot of these legislative documents, which is the recognition of the single biggest difficulty in bringing the case so long after the event. Sorry, I should refer you to paragraph 21 is referring to the experience of which was the only body designated previously to bring collective actions under the old regime. And they brought a single action concerning the price fixing of replica football shirts. So it's sort of a classic cartel action in which you wouldn't necessarily be able to identify the consumers who had actually bought the shirts, and you wouldn't have their contact details. And 22, the single biggest difficulty in bringing the case so long after the event was gathering claimants, a factor the defendants knew would militate against the representative body and was easily exploited, say the authors here. Even while the numbers affected were significant, around 1.2 to 1.5 million, very few claimants were named on the claim form at the end of the opt-in exercise. So that was the which experience. Paragraph 23 over the page is the passage that is relied on by the class representative, and that is the passage that identifies perceived weaknesses arising from opt-in mechanisms. And then if we turn to page 132, you see the authors at paragraph 26 saying the introduction of an opt-out system, however, could warrant any action being subject to more checks and balances, including close court management, which would include judicial discretion to conduct certification and permission hearings with regards to designated bodies. Paragraph 28 over the page. Again, they're emphasising the importance of certification in order to ensure, in the interest of the claimant class, defendants and the court, that a collective action is the most appropriate procedural mechanism in terms of efficiency, economy, fairness and access to justice. Before such an action should be permitted to proceed, it should be subject to positive certification by the court. And over the page again, page 134, see paragraph 29, where they say of particular importance in the certification exercise will be the assessment of the preliminary merits. So that's the sort of starting point where what was being advocated was a generic collective action. You then have the government consultation in tab 7. And this is the Department for Business Innovation and Skills publication, April 2012, this is page 139. Private actions in competition law, a consultation on options for reform. The court turns to page 151. You can see what's being consulted on at this stage, heading collective actions, and the government seeking views on. And the first bullet point is whether to introduce an opt-out collective actions regime for competition law to allow businesses and consumers to obtain redress. The regime would apply to both follow-on and standalone cases, with cases to be heard only in the Competition Appeal Tribunal. Page 154 is where the consideration begins, whether proceedings should be opt-in or opt-out. And if we go over to page 155, paragraph 5.18, you see again reference to the which example. Evidence suggests that the current opt-in arrangements for representative follow-on actions make it very difficult to bring cases. For example, which noted in its response to an OFT discussion document that the single biggest hurdle to the effectiveness of the current statutory representation procedure is the requirement to name claimants on the claim form. Paragraph 5.31. See that the government's expressing the provisional view that there will be a benefit for UK businesses and consumers in having a system of collective actions that's proportionate, balanced and achieved. I'm sorry, it's paragraph 5.31 on page 158.
Yeah.
And it says at the end of that paragraph, whether or not an action could be brought as an opt-out case would depend on the CAT determining whether or not this was the most suitable means of bringing the case, according to the parameters set out in more detail in Annex A. So that's the sort of provisional view expressed by the government in its consultation. If we then go on to tab 8.
What was the opt-in example that was given in 518? Is that the shirts cartel again?
My lord, yes, it gets mentioned repeatedly because it was the only case that was brought under the old regime.
And it makes the point that, you know, there were hundreds of thousands of potential claimants. They only drummed up 130 of them and they all got £20.
My lord, yes, because in my submission it is a classic cartel claim where you can't necessarily identify who it was that bought the replica football shirt.
Well, it doesn't say that's what it is, but that may have been.
Well, it says the single biggest hurdle to the effectiveness of the current statutory representation procedure is the requirement to name claimants on the claim form. That's which is evidence, and we see that again and again coming up. Tab 8. Page 165, this is the January 2013 publication by BIS, a consultation on options for reform government response. And if we go to page 176 within this, there's a heading, the government's decision. Paragraph 5.12 expresses the view that the current system of collective redress does not work. And then 5.13, you see the government does, however, firmly agree that strong safeguards would be needed as part of an opt-out regime. The design details will therefore be critical, and a range of safeguards, including certification, limited jurisdiction, no contingency fees or treble damages, and limits on the type of bodies permitted to bring cases are discussed further below. And you see in bold in paragraph 5.14, the government has therefore decided to introduce a limited opt-out collective actions regime with safeguards for competition law, with cases to be heard only in the Competition Appeal Tribunal. The government does recognise that there may be some collective actions which would be more appropriately brought on an opt-in basis, such as the case brought by a small number of businesses, all of whom are clearly identifiable. Just pausing there, one sees there a specific mention of the criteria of identifiability, and it is given in this case in the context of a small number of businesses. But in my submission, that's because one is contemplating, in contrast to the classic cartel claim, when one cannot identify the consumers. It's not in my submission limited as such. It's not specifically contemplating the relatively exceptional case that we have here, where you can identify the consumers that are likely to be party to the claim. Paragraph 5.16, again in bold, it's decided that the CAT will be required to certify whether a collective action brought in the new regime is suitable for collective action and whether it should proceed under an opt-in or an opt-out basis. And finally, page 186,
not quite right, is it? It doesn't have to certify whether it just has to decide that.
I'm sorry, my lord, I didn't quite follow the question.
Well, the requirement is that the CAT certifies whether the collective action, whether it's suitable for collective action. But then the CAT has to determine whether it's opt-in or opt-out. Is that right?
It has to certify both. So I showed your lordship, there's a sort of a three-limb test. Identifiability of the class, suitability for collective proceedings, and we temporarily blanked on the third limb of the test, but suitability is one of the limb of the test that the CAT must assess and certify as being appropriate, and that's what the case in Merrick's was about, the suitability test.
Right. I just understand. I'm just querying whether the concept of certifying whether it's suitable for should proceed under opt-out or opt-in.
Well, we saw from the rules that it must, when it gives the collective proceedings order,
Yes.
one of the factors that the collective proceedings order must specify is whether it's opt-in or opt-out.
It may be just semantics.
Is your lordship, it's the reference to the word certify that's... Yes.
I mean, certify usually implies something more than just making a decision. You have to a degree of certainty over the. No, it's probably it doesn't matter. I think.
They have to certify either an opt-in or opt-out, so it's a component of certification. You can't have certification without a decision one way or another.
My lord, that must be right. And essentially what's being said is that this is an exercise that the CAT must scrutinise, it must exercise control over it. And in that context, it's being contemplated that certain claims will remain appropriate for opt-in, notwithstanding all the various perceived problems with opt-out claims.
Yeah.
And in fact, it may assist that there is a heading certification on page 186. And the government strongly agrees with the great majority of respondents, this is paragraph 5.54, that a certification regime is an important safeguard. It welcomes the consensus that the issues identified in consultation are broadly correct, and thanks to those who raise new issues, the government therefore has decided there should be a strong process of judicial certification, including a preliminary merits test. An assessment of the adequacy of the representative. My lord, that was the limb that I couldn't call to mind when I was responding to your lordship's question. It's the class representative. Requirement of the collective action must be the best way of bringing the case. We then have in tab 10, House of Commons, page 239, House of Commons Business, Innovation and Skills Committee report on the Draft Consumer Rights Bill, 23rd of December 2013. And your lordship will see if you look at page 251. Proposal 2 to provide for opt-out collective actions and opt-out collective settlements. And if we look at paragraph 273, you see again reference to this experience of which, at the end of this paragraph, the greatest barrier is reaching consumers who have suffered detriment due to the current opt-in system, and has stated that it would not bring another action under the current procedure. In my submission, that is particularly clear, because what's said there is the greatest barrier is reaching consumers. In the context of the point your lordship was putting to me about whether there's a distinction between identifying them and persuading them to opt in, the convertibility, what which is saying there is that the barrier is reaching the ones who have suffered detriment. And finally, just for
it's difficult
completeness,
to place too much reliance on that, because that's based upon the then experience of using the then procedure, which was saying was totally inadequate, and obviously that was the experience they'd had in the only one they'd actually got on foot. So,
my lord, yes, but it does explain why you then see in the guide an indication that if you can identify and contact the consumers, then that might be an indicator that opt-in is appropriate, because that is the salutary experience that they're trying to address here is the inability to reach the consumers who have suffered detriment.
I think the problem in shirts, it was Manchester United and England shirts which was mainly the problem. Most of the money was paid for by mums who didn't keep till receipts.
I thought that may well have been right.
Yeah.
And that in my submission illustrates the point that that is the classic cartel experience, and that is one where an opt-out proceeding is clearly warranted. And in my submission, what you see coming through from this material is that where you can identify and contact these people, that is indicative that you can persuade them to opt in.
Quite a lot of these problems are overcome through the mechanics of an aggregated damages as well. That smooths out some of the practicabilities, or practical problems which arise.
My lord, that's exactly right, and that's a point that will come out of the Lloyd judgment, because in the Lloyd judgment, it identifies various hurdles to collective proceedings, of which one is the obligation to conduct an individual assessment of damages, and makes the point that under the collective regime, that is now rectified.
It's quite interesting that and I'm not sure how permissible it is to look at this material, frankly. But if you look at paragraph 275, the last sentence on that page, I think it's the same page as we're on. The government said, this is in the context of the certification process. This is because there may be some collective actions which would be more appropriately brought on an opt-in basis, such as a case brought by a small number of businesses, all of whom are clearly identifiable. So the government appears to have been contemplating that actually opt-out would be the more common in these sort of large cases with small amounts of large numbers of consumers and small individual claims for damages.
My lord, that is the passage that I showed you in the previous government consultation, where the government had said that, and I made the submission that the assumption they're making, and it's an understandable assumption, is that you're unlikely in normal consumer claims to be able to identify the consumers involved. Because you're going to have the classic football replica shirt situation where you just don't know who bought the shirts. That's a fair assumption, but in my submission it doesn't preclude recognising that in a situation such as the present case, where actually exceptionally you can identify the consumers involved, the importance of the identifiability criteria, which is what the government is emphasising here, is a very strong pointer towards opt-in proceedings being practicable.
Well, if you knew that there was some claim which was could be brought by each and every single person who was domiciled in the United Kingdom, you'd be able to identify all 65 million. But that wouldn't mean it would be sensible to have an opt-in scheme.
Well, my lord, the difficulty is that in most cases you don't know, you can't define the class that precisely. You would be saying it's everybody who bought this product, but you have no idea who bought the product. And even if you knew who bought the product, you don't have access to contact details in order to
Let's say there was a
contact.
claim by every single registered voter for some wrong done to them by a voter, so you knew that all registered voters had a claim. Would you say because you can identify them all, they should? That means that it should be an opt-in scheme.
Well, my lord, certainly I would say that.
35 million.
Certainly I would say that what's coming through from this is that the mischief they're trying to address, particularly from paragraph 273, is that the greatest barrier is reaching the consumers who have suffered the detriment. If you can reach them, you can seek to engage them. And of course, in a proceeding such as that, if you're purporting to bring your claim on behalf of all those people, you have to have a plan as to how you're going to distribute the damages. And so at some point, those people are going to have to be identified, and that's exactly, in my submission, the slight cleft stick that the class representative finds itself in this
All the time
case.
keep bringing us back to the crediting the account.
It is an important point, my lord, yes, it is.
You're going to come to that.
I will, yes.
An account credit wasn't, I mean, I know you're coming to Lloyd in due course, but Lloyd took a broader, more helicopter view. Big numbers, small claim, complex claim. Almost, they didn't quite put it in neat terms. Suitable, therefore, for opt-out.
Well, Lloyd was actually considering a claim that wasn't brought under the the Consumer Rights Act
You'll probably
regime.
say it was overture in every respect.
It was not in any way considering the construction of these provisions.
No.
But I do have some very specific submissions to make about the fact that some of the obstacles identified in Lloyd are then addressed in the collective action regime, such that one can't conclude that general obstacles to opting in mean that it's not practicable in the context of this regime. I was finally just going to show your lordships the consultation which relates to the CAT rules. I just rely on a single paragraph in that, which is page 265 in tab 11. Paragraph 7.4, where it's being said it's imperative that the rules which govern collective proceedings and collective settlement are as rigorous as they can be, and that the merits test is robust, and the right balance is struck in protection of the rights of all parties involved. In terms of what, in my submission, the court can derive from these legislative materials, I don't shy away from the fact that the potential for opt-out proceedings was introduced because of the perceived difficulties of opt-in proceedings, but I do emphasise that in full knowledge of those difficulties, this regime has retained the possibility for collective proceedings to be opt-in, and it's contemplated that that would remain the most appropriate course of action in certain circumstances. What you also see from the materials in my submission is what's being introduced as a limited opt-out regime with safeguards. We've seen that the safeguards include the role of the tribunal to certify whether opt-in or opt-out is appropriate, and we've seen that they include a robust merits test. And that feeds through, in my submission, to Rule 79(2)(b), where it says that the tribunal will consider whether it's practicable for proceedings to be brought as an opt-in proceedings, and the indication in the guide that there's a general preference for opt-in proceedings where practicable. In my submission, that follows from the limited regime with safeguards that the legislative regime contemplated.
When you say limited, when you say limited, I'd understood the CV to be limited to competition law, not limited to preference for opt-in or opt-out. I mean, the word limited was, shall we introduce a class action scheme beyond competition law? And that sense limited. I'm not saying it adds much to the debate that we're having.
Your Lordship might be right, but the reference to safeguards in my submission does. The phrase, I use the phrase limited with safeguards because that's the phrase that appears in the in the consultations.
Yeah.
And thirdly, in my submission, the legislative materials give us a clear steer as to the circumstances in which opt-out proceedings or opt-in proceedings might well be practicable, because they saw the repeated focus on Which's experience and its inability to identify and contact the customers that had suffered loss. And that is described, again repeatedly, as the primary obstacle for opt-in proceedings. And we saw specifically the possibility of identifying potential claimants being put forward by the government as an example of circumstances where opt-in proceedings might be appropriate. And that, in my submission, is duly reflected in the provisions of the guide, where they indicate indicators that an opt-in approach could be workable and in the interests of justice. Turning to look at what the CAT made of it in its judgment, this is Core Bundle tab 13. We start at page 348. You can see at paragraphs 20 to 24, the CAT sets out the applicable legal provisions relevant to opt-in and opt-out. And then from page 358, so paragraphs 48 to 109 are dealing with BT's strikeout summary judgment application. And so the section where the CAT begins its consideration of opt-in, opt-out starts at paragraph 110 on page 375. The court will see that the tribunal rightly holds in our submission at the end of paragraph 110, at the end of its first paragraph, it says we agree that the fact that the PCR does not seek an opt-in basis as an alternative does not absolve it from demonstrating the tribunal from being satisfied that the opt-out basis is more appropriate. In our submission, that is correct. One then sees at paragraph 111 that the tribunal is recording Mr Bunt's evidence that potential claimants are easily identifiable and contactable. And so it will be relatively straightforward for such customers, A, to be informed of this action, and B, then to decide whether or not to join it. And it points out that at the end there, BT points to the fact that the PCR now relies upon this feature of the claim to explain how simple it would be to distribute any damages or equivalent remedies, since the class to be compensated can be identified. So, certainly, it was uncontested before the tribunal that that was the case, and insofar as the class representative seeks to take issue now with whether or not the class are identifiable and contactable, in my submission the tribunal has essentially in paragraph 111 made a factual finding to that effect. It's positively indicated that the PCR relies upon this feature of the claim. Paragraph 112, the tribunal records the submission on behalf of the class representative that there is a real difference between the option to join a legal action at the outset and claiming a damages entitlement later on once the case has been won. So it's there recording an assertion that's made on behalf of the class representative. And at the end of this paragraph, you see the tribunal specifically recording the point that, as canvassed with counsel during the hearing, the distribution of damages could be achieved without any active participation of the relevant customers at all, because their BT accounts could simply be credited with a relevant amount. And they say 113, we say more about this feature of the claim below. At the beginning of 114, the tribunal is again recording an assertion that's made by the PCR. It says the PCR contends that there is little prospect that the 2.3 million customers who will be within the scope of the action would be sufficiently proactive to opt in, given the demographic of most of them. And it elaborates on that submission. End of paragraph 14, you see nonetheless, in our judgment, the position at this stage is not at all the same as at the distribution stage for the reasons already given. In my submission, when one asks oneself, well, what reasons have been given, the tribunal itself has not actually given any reasons. What it has done, it's done two things in my submission. First, it has recorded the assertions that have been made by the class representative. And secondly, it's recorded the notion that the distribution of damages can be achieved without active participation. So on any view in my submission, this is not a well-reasoned assessment. Paragraph 115, the tribunal...
Well, it depends how you interpret paragraph 112, doesn't it? I mean, it's true that paragraph 112 starts off by referring to the PCR's call response, but as you read on, it seems tolerably clear that this is the tribunal's view. And that's why they come on, for example, to say, indeed, and as canvassed with counsel during the hearing, distribution damages, etc. That's an expression of the conclusion of the tribunal. And that's why they rely upon what was said by the President in the Gutman case. So I think it's, you may be right that the reasoning is not extensive, but I don't think you can say that they haven't given reasons why the position is different at the outset from the distribution stage.
Well, in my submission, my Lord,
112.
the entirety of paragraph 112 is recording the submission that's made by the PCR.
Well, it starts off that, but it's not.
Well, I showed your Lordship.
I mean, this is, and it's not intended to be critical one way or the other, but some tribunals and judges write judgments in ways which sometimes don't distinguish as clearly as they might between what's the submissions of counsel and what's being accepted and adopted by the court or the tribunal. And this may be such an example. If you look at it overall, it seems to me to be an expression of the views of the tribunal.
And if it ain't, your problem is the last sentence of 114. In our judgment, the position is not at all the same for the reasons given, bracket, by the PCR. They've
Yes.
just endorsed them.
My lord, in my submission, it's unsatisfactory reasoning simply to record the submissions given by the PCR as such in paragraph 112, and then say, for the reasons given.
Well, that's perhaps not your strongest point.
And is it a point of law appealable? I mean,
My lord, it's not, but it is context. It's not the point I rely on.
That's
But we-
very, very cleverly done.
Paragraph 115 is a further submission on the part of the class representative. The PCR contends that if, as he predicts, too few customers opt in, required third-party funding will not be attracted. In reality, the claim would never get off the ground. And we then see the statement, it is hard to see an answer to this point, save for the one which we have rejected, which is that in reality a large number of the relevant customers would opt in. I do respectfully criticise the reasoning here as well, because in my submission saying, well, it's hard to see an answer to the point is not a reason to reject it. And then the effect of the final sentence is simply to refer back to the assertion that a large number of relevant customers would opt in. Again, there's no additional reasoning here as to why that actually might be the case. What in my submission is going on is that the class representative's assertion that there is a relevant difference between the outset of proceedings and the distribution stage is being accepted uncritically and without any independent analysis on the part of the tribunal. Paragraph 116, the tribunal rightly attaches no real weight to the point about the purported effects of brand loyalty to BT. We then come on to 117 and 118, which are the paragraphs where the tribunal is considering the question of jurisdiction. And it recalls that in the course of argument, a point was taken by BT as to whether if the PCR won, the tribunal would actually have jurisdiction to enable damages to be paid out to each customer. So it's recording our submission. Our submission, it was, thus this direct method of compensation is simply not available. The tribunal says for our part we do not accept that the position is as clear as that. The other person could be a claims administrator instructed by the PCR, who would then, with the assistance of BT's records and technology, be able to effect the relevant credit or something similar. Indeed, on the face of it, the other person could be BT itself on a specific direction of the tribunal. So those are the two possibilities that the tribunal deals with that I'll come back to. And they express a view in 118 that it would be extremely odd if Rule 93.2 interpreted in a common sense way would prevent this obvious way of compensating customers who have won. We appreciate that Rule 93.3 states that the relevant CPO may specify the date by which represented persons shall claim their entitlement to a share of that aggregate award. Whether that's a discretionary power, we do not accept that this power must entail that in a case like this, a customer must positively claim the remedy as opposed to simply collecting it. They then go back to the point made on behalf of BT that on the PCR's own proposed plan, if the claim succeeds, the customer must fill in a claim form. And you see the tribunal offering two answers to that 119. A, it says the process may change, so it's referring back to the possibility of direct credits to grapple with that difficulty. And they say B, this doesn't overcome the difference in principle between a relevant customer engaging at the outset as opposed to the end stage when informed they're entitled to compensation. So back again to the point that in my submission has been accepted without any independent analysis. Paragraphs 121 to 123 are dealing with the defence of pass-on, and the short point that we derive out of this is that the tribunal is contemplating in these paragraphs that it might be necessary to contact customers for the purposes of ascertaining whether they use their line for business purposes. Paragraph 124 is the sole paragraph that deals with the strength of the claims in the context of opt-in, opt-out. And you see the approach the tribunal takes there. It says it could only assist BT here, in our view, if it could persuade us that this is a very weak claim, even if it could surmount the summary judgment strikeout threshold. And then conclusion at 125, therefore, is that the opt-out basis is clean, more appropriate and suitable than an opt-in basis. I should show the court briefly what the tribunal said on permission to appeal.
That paragraph 124, I agree with you, is a very odd paragraph because the reference to a very weak claim, I'm not entirely sure where they got that from. When they talk about the reasons given, for the reasons already given, they're referring back, aren't they, to all the reasons they gave for rejecting your summary judgment.
My lord, they are, yes.
Which isn't being appealed, obviously.
It's not.
So you can legitimately say, well, that's a very odd way of putting it, but if one looks at it overall, what they really seem to be saying is because you don't hit the summary judgment threshold for all the reasons we've given, then you can't show that it's not appropriate for it to be an opt-out.
Well, my lord, we do say that the approach that's been taken here is not appropriate and is not supported by the rules or the guide. As your lordship rightly points out, there's no reference to a very weak claim. Insofar as the tribunal has purported to take this into account, it needs to weigh it up appropriately in the context of its assessment, not simply say you need to persuade me it's a very weak claim in order for it to be of relevance to this assessment.
Right, I'm fine with that point. Yeah. Okay, you can show us the ruling on permission to appeal.
My lord, yes, it's tab 14, starting page 387. Paragraphs 15 to 17 are those where the tribunal is dealing with our proposed ground 1. What it says in summary, paragraph 15, the tribunal says it engaged in a reasoned multifactorial assessment and there was no error of law, and it makes reference to merits, which obviously are a judgment about the test for suitability rather than practicability. At paragraph 16, it refers to the Ofcom materials on levels of engagement, but in my submission it doesn't explain how it then squares the circle about the difficulties arising from those levels of engagement at the distribution stage as well. And at paragraph 17, it says there was no error of law in referring to the putative lack of third-party funding. But you have my submission about the lack of reasoning there as to why that was a submission that was accepted, and then that lack of reasoning isn't rectified in this judgment either. In paragraph 18, the tribunal turns to ground 2, and it says no concluded decision was made on the question of jurisdiction. That's at the end of paragraph 18. In paragraph 19, it reiterates the point that there remained the difference in principle between the two stages of potential engagement at the outset and on collecting damages. It then says the fact that more contact might be necessary where a pass-on defence is relevant or in respect of customers now deceased is not material. So it dismisses that point. And ground 3, it says there's no error of law in relation to reference to the merits. And it says at the end of paragraph 20, it says we're entitled to say that in this case the claim would nonetheless have to be very weak for the merits to have any further impact on the opt-in, opt-out decision.
I have, like my lord, have a little bit of difficulty with paragraph 124, and I'm not certain this cures it. And I think the problem with 124 is that it seems to imply that over and above the summary assessment procedure, there is a yet further hurdle that the BT has to meet, which is that the claim is very weak. Well, if they've decided it's realistic and arguable, then there can't be any further hurdle that has to be met about weakness or otherwise. And it also seems from paragraph 110 that they dealt with the merits and then they largely set the strength of the case aside and said, okay, you know, the class have overcome the threshold issue, and they didn't really seem to address it further rather than in that rather opaque 124. I'm not certain this actually adds very much to that.
Well, paragraph 20 of the reasons you just showed us seems to be suggesting that the claim would nonetheless have to be very weak for the merits to have any further impact on the opt-in, opt-out decision. Which seems to be saying, even if you've said you've got a sufficiently arguable case, or reasonable prospect of success or whatever it is, then for it to have any further impact, you'd have to show that somehow the claim was very weak. Well, that is completely inconsistent, because by definition, they've decided that the claim wasn't very weak.
My lord, they've decided it
Very
passed
point
the
they had to
strikeout
Yeah.
test. And of course, they're saying for it to have any further impact, of course, they have purported to take it into account in accordance with the direction in the rule. That is a factor you are entitled to take into account and opt-in, opt-out. And in our submission, it's then an error of law to say that it can't then have any further effect. It's got to be weighed in the balance appropriately. You can't simply dismiss it and say, well, you failed to show me that it's very weak, and therefore I'm not going to allow it to register on the scale.
One's got to be realistic about this in this sense. If you hadn't launched your cross-application, the tribunal would have had to deal with the merits in much more detail than they did in addressing the Rule 79 question. It didn't do that because it had already dealt with the merits and dismissed it. You're entitled to say 124 is sloppily worded. It's not entirely clear what they mean, but I'm not sure you can go as far as saying it's an error of law, because underlying all this is the conclusion that the merits were sufficiently strong for the purposes of Rule 79.
Well, my lord, I do say it's an error of law because it is opposing a test which, in the context of opt-in, opt-out, which has no support whatsoever in the rules or the statutory scheme. It is saying, and it's reiterated in this paragraph, that we will not be taking this into account unless you can show that it's very weak, and that in my submission is an error of law, because having purported to consider the merits in accordance with its discretion to do so in the rules, it needs to take them into account appropriately. It can't simply say you need to persuade this is very weak in order for this factor to be weighed in to the consideration. That in my submission is a hard-edged error of law because it's implying an incorrect test.
Just to think about what the tribunal is saying. They have considered the merits and they've come to the conclusion there's a real prospect of success. What further could be argued about the strength then at this very early stage? They decided this is a case with real prospects. You could, I suppose, argue that even though it's got real prospects, it's one of those cases which I saw Sir Michael Burton refers to in one judgment as being a real squeaker. It just got over the line, as it were. I suppose you could say, well, it's got a real prospect of success, but only just. And he's saying, but we've not been persuaded of that. So what more can we say at the moment? Isn't that what he's saying?
It is a factor that the tribunal is entitled to take into account in weighing up whether opt-in or opt-out is more appropriate. And the guide tells us, first of all, that opt-out proceedings entail greater complexity, costs and risks. And so for that reason, the tribunal will expect the strength of the claim to be more immediately perceptible in an opt-out
Why would
case.
that be so? I've got a little bit of difficulty in seeing that opt-out is more complex necessarily than opt-in. It just seems to me every case will be very different. I mean, in some respects, if it's properly funded because it's opt-out and you've got decent experts and resources, it might be more streamlined and efficient than a messy opt-in where claimants are short of resources. I mean, I'm not certain I see the generality expressed in the guide is inevitably correct. And in this case, it seems to me that the merits almost went more to certification than to opt-in or opt-out. Because if they'd failed, you plainly wouldn't have certified the proceedings. It would have been a demurrable claim. That would have been the end of it. They met the threshold. It was therefore certified. Then they come on to opt-in or opt-out. At a 110, they say, well, we've dealt with the merits. Now we'll move on to other things. And you get this rather odd paragraph 124, which you've made perfectly cogent submissions about. But standing back, I mean, this was a case where Ofcom had conducted a very detailed review, not a follow-on, but the Ofcom findings had some weight, if not binding, plainly not binding, provisional, prospective. They didn't cover the past, but the tribunal was bound to accord them some weight. I'm not certain the tribunal saw this as a marginal strikeout claim.
My lord, in my submission, if one looks at the guide, the key concern is that in an opt-out case, members are being represented without having chosen to be part of the proceedings. And so the safeguard for both for their interests and for the interests of a defendant who should not be subject to an unmeritorious opt-out claim is that the tribunal must scrutinise the merits, or may scrutinise the merits, I should say, and those merits must be more immediately perceptible in an opt-out case. So you do have to reach essentially a higher degree of satisfaction that this is a valid claim. And in my submission, the tribunal hasn't properly turned its mind to the relevance of the merits in the context of the opt-in, opt-out inquiry. They've simply said, well, we've dealt with this on a strikeout basis. It would have to be a very weak claim for it to be of any further relevance in the exercise of our discretion. And in my submission, that is an error of law.
If they concluded that it's a claim that has a real prospect of success, after a detailed analysis of your arguments to the contrary, have they not considered the strength of the claims for the purposes of Rule 79.3?
Well, in my submission, not for the purposes of...
What are you submitting that there's some higher level of merits assessment that's required of the tribunal than the detailed one it engaged in for the purposes of strikeout and summary judgment?
My lord, no, I'm submitting that they have not applied the correct test at the point at which they come to consider opt-in or opt-out, because they need to recognise that the strength or otherwise of the case will inform whether it's appropriate to bring it as opt-in or opt-out, and they have not done so.
Right.
My lord, I'm hoping that my submissions on the various grounds can go fairly quickly, because of course we've canvassed a lot of this.
Well, yes, I'm sorry if we've been interrupting you.
No, not at all. I'm seeking to assure your lordship that I'm hopefully making progress.
So you finished the introduction now.
Indeed, that's where we've reached.
3 short points.
Starting with ground one, as is convention. As the court will now appreciate, our ground one of appeal is that in permitting these collective proceedings to go forward on an opt-out basis, the tribunal has misdirected itself in law as to the meaning of practicability in Rule 79.3. And we've shown you that in making its judgment, the tribunal may take into account whether it's practicable for proceedings to be brought as an opt-in. The factor which the tribunal has purported to take into account in this case, but in our submission, it has made an error of law as to the meaning of practicability in the context of this statutory scheme. And we place particular emphasis on the wording of the guide, which indicates that it could be both workable and in the interests of justice. That it's for it to be opt-in, because indicators that an opt-in approach could be both workable and in the interest of justice might include the fact that it's straightforward to identify and contact class members. In our submission, there is a finding of fact, and it was uncontested at least below, paragraph 111 of the judgment, that class members are easily identifiable and contactable, and so we're not faced with the sort of case like which, where there's a class of persons who have suffered harm, but you can't identify who they are, and you can't seek to try to persuade them to opt in. This takes it well away from a classic cartel case, which was the driver for the 2015 Act. And we say it's not only BT that's saying that this is a class which could be actively contacted and encouraged to participate. It's the class representative that is proposing to do so as part of its distribution plan. And we do emphasise that there is barely any difference between the steps that the class representative proposes to engage in at the end of the proceedings and the steps which need to be taken at the outset. And that, in my submission, is why it is no answer to say that in the particular context of this case, even if you could contact these particular class members, there's something about the particular characteristics of this class that means that they can't be expected to take active steps to opt in, because the class representative is expecting them to participate fully at the distribution stage. Now, I've shown you that the tribunal addressed this by saying that there's a difference between the opt-in stage and the distribution stage. And in my submission, it's clear from the judgment that at least one limb of its reasoning was to say that distribution might be capable of being achieved without class members' active participation. And we do say that's an error of law. That's our ground too. The tribunal indicated in refusing permission that it didn't reach any concluded view on the point. But in my submission, it's clear on a fair reading of the judgment that at the very least it was a material part of its reasoning. I've shown you that the tribunal's reasoning as a whole is pretty terse, and a material proportion of it is taken up with references to and discussion of the possibility that damages could be distributed directly. So we do say it's clearly a material factor, and I'm going to come on to address why we say that's wrong. For the purposes of ground one, the other limb of the tribunal's reasoning is its acceptance of what we say is essentially an assertion on the part of the class representative that potential class members were less likely to opt in at the outset. And I do maintain my submission about the unsatisfactory nature of the tribunal's reasoning on that point. Even if it was right that there is a general tendency to be more inclined to participate at the distribution stage than at the opt-in stage, in my submission that is not enough to render the proceedings impracticable for the purposes of the statutory test. The reason for that is it will be the same in every claim. If there is a general tendency that people are more likely to step up when money is available to them, you would never get a claim certified as suitable for opt-in. And that, in my submission, is not what this regime was contemplating. The tribunal also referred to the third-party funder's preference for opt-out proceedings rather than opt-in proceedings. And again, I maintain my submissions about the paucity of reasoning in support of that. But I do make the submission that nothing in the legislative scheme that we have looked at requires the tribunal to defer to the preferences of the litigation funder. And it would completely undermine the scheme if it were to do so, because a funder can always express a preference for opt-out proceedings. And the proposed class representative can always say, well, that means that no claims will be brought at all if you insist on certifying on an opt-in basis, and therefore access to justice will be precluded. So, in my submission, giving preference to the litigation funder in this context undermines the statutory scheme. Turning to deal with the class representative submissions under this ground of appeal, first it's argued that these are all factors that the tribunal is entitled to take into account in the exercise of its discretion, and so there's no error of law. In my submission, because the tribunal has taken an erroneous approach to the test of practicability, and that test forms one part of its multifactorial assessment, that erroneous approach vitiates the entirety of its assessment. Secondly, the class representative has sought to suggest that the Supreme Court's judgment in Lloyd and Google is an answer to the points on this appeal. And the court will have seen the heavy emphasis placed on that case in the class representative skeleton. Can I ask the court to turn it up? It's an authority manual, tab 11, starting at page 281.
Give us the reference again, tab 15.
Sorry, tab 11, my lord. It's page 281. The court will see from paragraph 1, which begins on that page, that this is a claim against Google alleging breach of its duties as a data controller under the Data Protection Act. And what's being said was that Google secretly tracked the internet activity of Apple iPhone users, and it used the data commercially without users' knowledge or consent. And paragraph 3, the Supreme Court is recording that there's no generic class action regime. We saw the Civil Justice Council report that proposed that, but it wasn't introduced. And so the claimant in this case was required to use the representative procedure in CPR Rule 19.6. You can see recorded in paragraph 5 here, Mr Lloyd has sought to overcome this difficulty by what the Court of Appeal described as an unusual and innovative use of the representative procedure. Paragraph 8, the Supreme Court explains that whether the representative procedure can be used in the way that the claimant tried to do, depended on whether compensation for breaches of data protection law needed to be individually assessed or not. And ultimately, in this case, the Supreme Court held that it wasn't a suitable procedure for bringing this sort of claim. If we look at paragraph 24 on page 286, this is the beginning of the passage on which the class representative has placed reliance in their skeleton. And the court will see it's under a heading, collective redress in English law. And it's got a subheading, group actions. So these paragraphs that have been quoted and reliance is placed on them are not specifically dealing with the Consumer Rights Act regime. If we look to paragraph 27, this again is a passage which is quoted in my learned friend's skeleton. We see likely explanations for the low participation rates typically experienced in opt-in regimes include lack of awareness of the opportunity to join the litigation and the natural human tendency to do nothing when faced with a choice which requires positive action, particularly if there is no immediate benefit to be gained and the consequences are uncertain or not easy to understand. Now, the class representative has placed great emphasis on the second point there, but it hasn't in its skeleton mentioned the first point. Lack of awareness of the opportunity to join the litigation. That's obviously a point that can be addressed where a class can be identified and contacted. If we look at paragraph 28, we can see the Supreme Court saying a further factor which makes group litigation impractical in cases where the loss suffered by each individual is small, even if in aggregate it may amount to a very large sum of money, is the need to prove the quantum of loss in each individual case. Again, this is an obstacle which has been addressed in the collective action regime by an aggregate award of damages, the possibility of claiming an aggregate award of damages. And we can see that paragraphs 30 and 31 of the judgment where the Supreme Court is setting out the developments in the collective proceedings regime. Paragraph 30 is pointing out that you can now bring opt-out proceedings. And paragraph 31 is pointing out a second significant feature of the collective proceedings regime is that it enables liability to be established and damages recovered without the need to show that members of the class have individually suffered loss. It is sufficient to show that the loss has been suffered by the class viewed as a whole. That is the effect of section 7C2 of the Competition Act, and that's the provision that I've shown the court already. Ultimately, the Supreme Court concluded that the underlying claim in this case had no real prospect of success, and that, for your lordship's note, is paragraph 159. But I emphasise 3 points coming out of Lloyd and Google. The first is that the remarks on which the class representative has placed quite a lot of reliance in its skeleton argument are not made in the context of the Consumer Rights Act regime. They're made in the context of consideration of group actions under the CPR. And although it cross-refers by way of comparison to the new regime for competition law claims, the Supreme Court is certainly not, in this case, purporting to construe the dedicated regime for competition claims. And it's certainly not turning its mind to or considering the particular point that's in issue in these proceedings about whether you certify collective actions where the members are contactable as opt-in or opt-out. It's not considering that issue at all in my submission. Secondly, in my submission, the class representative has glossed over the other explanations for low participation rates that are spelled out by the Supreme Court. Lack of awareness of the opportunity to join the litigation and inability to prove individual loss. Neither of those apply in the context of this case because the class is contactable and because the claim is for an aggregate award of damages. And thirdly, in my submission, the emphasis on people's tendency to do nothing proves too much, because it is in full knowledge of this tendency and of the inefficacy of opt-out proceedings generally that the legislature retained the possibility of an opt-in regime and indeed expressed a preference for it where practicable. So in my submission, pointing to general tendencies not to opt in, which apply universally, cannot be enough because that would mean you would never have a case where opt-in is appropriate. And in my submission, it's very clear that that was not what was intended. So our submission is Lloyd does not assist this court to determine the issue that's before us. What we do say is more informative is the approach taken by the tribunal in the McLaren case, which is the one I mentioned earlier. That is in Authorities Bundle tab 13. It starts at page 345, my lord. And this is a recent application for collective proceedings which arose from a commission infringement decision in relation to maritime car carriers. And so it's a decision taken under the CPO regime. The tribunal's consideration of opt-in, opt-out starts at paragraph 151 on page 394. And it covers some 8 pages or so of reasoning. And in my submission, there is a striking contrast with the relatively terse consideration of opt-in, opt-out given by the tribunal in the present proceedings. What was being proposed in this case, what was being suggested by the respondents, was that a particular group of what were defined as large business purchases should be split off from the main class, and their claim should be opt-in, and the remainder of the class should be opt-out. So that's what the tribunal's grappling with in these paragraphs. And paragraph 153, you see the tribunal endorsing the position taken by this tribunal in paragraph 110 of its judgment that the PCR was not absolved from demonstrating that opt-out basis was more appropriate simply by not presenting it as an alternative. They report that that's the respondent's submission, and they say we see force in this submission at paragraph 154. They say it would be very surprising if by framing the application in a particular way, the tribunal was precluded from refusing to certify proceedings on an opt-out basis in circumstances where it considers that they should properly be brought on an opt-in basis.
Does all that mean that even if an applicant claimant does not draft the application by reference to opt-in, the tribunal still has that option?
It still has that obligation.
It can't be bounced into a choice simply because of some forensic decision taken by a claimant.
My lord, yes, it can't be told, well, I've only offered an opt-out proceeding, and so you, tribunal, are not required to consider whether opt-in might be more appropriate.
I mean, if they then say that opt-out is inappropriate, but we would have opted opt-in, but you don't want it, well, they dismiss the claim. Or they say, well, you'll have to come back and, I mean, that may be the option. If you don't want opt-in, then the claim is dismissed. Certification is denied.
My lord, yes, what's I think being informally canvassed is if the only option on the table is an opt-out, then the class representative has an opportunity to go back and say, okay, well, you can, if you wish, renew the application as an opt-in because we consider that's more appropriate.
Yeah, but you're not bounced. The point is you can't be bounced as the tribunal. Yeah.
My lord, yes.
It can't be bounced, but it seems to me it must be a factor which is capable of being taken into account, that the representative is only proposing and only prepared to proceed on the basis of opt-out.
Well, my lord, this ties into the submissions I make about the relevance of funding, because it would be very easy for every class representative to say, I only wish to bring an opt-out claim, and therefore you, tribunal, are faced with the possibility that if you say no, then there will be no claim at all, and so there will be no access to justice for these individuals. And in my submission, that is an inappropriate way to proceed, because it means that you can always be precluded from finding something's opt-in because of the threat held over your head in terrorem that would mean that there will be no claim.
No, but I think that's a different. It's different to say that it can't be determinative and it can't be held over your head. But in considering whether or not it is workable and practicable, it must be a relevant factor that the persons considering bringing this claim and funding it don't consider that it's going to be worthwhile bringing it on an opt-in basis. It's real world evidence, and we're not here talking about. We're talking about the fact that this will not go ahead on an opt-in basis. At least that's what's being said, and if that is accepted as being true, then it seems to me it's a material factor to be taken into account.
Well, my lord, that does in fact raise a very important question, because one must ask, well, what evidence is there that this could not proceed on an opt-in basis? It's a very easy matter to say, well, we have chosen to bring it on opt-out.
Well, because it's in the interests of those bringing the claim and those funding it to bring the claim if they can.
One might indeed think so, but of course, if the tribunal is minded to accord undue weight to an expression of opinion, absent evidence that it would not be viable to bring the claim in another form, then it's much more likely that the tribunal will certify as opt-out, and there's no incentive to offer opt-in.
You're entitled to say that the tribunal must exercise judgment over a submission that the funders would only fund opt-out. But the tribunal, I mean, we've looked to see what evidence there was behind the funder's position, and is covered in witness statements. You may say it's not very much, but nonetheless the tribunal had evidence before it and exercised judgment over that evidence to accept the funder's position. And I can see that they can't just willy-nilly just say, funder says so, therefore, because that would be to abrogate their responsibility to exercise judgment over the facts.
Equally, you can see, can't you, that unless you, in any given case, unless the funder has actually made an effort to see if they get people to opt in, and it's been a complete disaster, which might be an expensive exercise that they wouldn't want to engage in. It's always going to be a case where the class representative on behalf of the funder is saying, well, look, this is the sort of case where opt-in isn't practicable, and the tribunal has to make an assessment as to whether you call that an expression of opinion. I see that point. Whether there's any force in that that piece of evidence, but that's a matter for the tribunal, not for this court.
My Lord, I would respectfully agree that the tribunal must make an assessment. I make 2 points. The first is that the tribunal's assessment in this case is unsatisfactory for the reasons that your Lordship has. It's a single paragraph which doesn't provide any reasoning whatsoever. And my second point is that in this case, the evidence available falls very short of a situation where either the class representative or the funder is saying it would not be possible for me to fund this as an opt-in claim. There is not such evidence before the tribunal.
McLaren is really dealing with a different point, isn't it? I mean, the main point of McLaren was the attempt to, as it were, carve out a special category of within the class.
My Lord, that was the suggestion that was made, but the particular paragraph that I place reliance on is paragraph 166 on page 399, and that is that's where this tribunal is considering the evidence that was advanced on behalf of the class representative in that case as to why opt-in might cause concerns. And so the tribunal is recording the applicant relied on Ms Holloway's witness statement. This raised a number of practical concerns about the respondent's proposal, including the absence of a central body that could be used to identify and communicate with large business purchasers, challenges in persuading large business purchasers to opt in, and the consequential difficulty in book building class members cost effectively, and the absence of benefit to members of the class. There are essentially two categories of evidence there, and the tribunal splits them out and deals with them separately. It says, we would observe that the need to persuade class members to join opt-in proceedings is not by itself a good reason for choosing an opt-out approach. The preference that the guide expresses for opt-in proceedings reflects the fact that it is generally a positive thing for there to be critical assessment of claims. More persuasive are the points Ms Holloway makes about the broad range of businesses that may fall in the large business purchaser category, such that communication through one or a limited number of industry bodies is unlikely to be feasible, and book building more difficult, with a consequential effect on costs and potentially viability. Since the CAT rules pose the question whether opt-in proceedings are practicable, that point is relevant. In my submission, the tribunal is rightly distinguishing between two things here. On the one hand, you have factors that go to your ability to persuade people to opt in once you've contacted them. And on the other hand, you have, once you've identified, before you can identify and contact them, you actually need to be able to, for example, use an industry body to communicate with them. And the tribunal's saying, if you can't, if because of the lack of an industry body, the inability to identify these people, you can't contact and identify them, then proceedings might well be impractical. But they're saying if you can identify and contact them, the fact that you need to spend effort and resources persuading them to opt in those circumstances isn't a valid factor, which suggests that opt-in proceedings are impracticable. So they're
Well, it's
drawing quite an
saying it's
important
not-
distinction there.
It's not by itself a good reason. It's not saying it's not something that can be taken into account as one of the factors which the tribunal can,
Well, my
to
lord,
which
I
the
think
tribunal can have regard in any given case.
they are saying it is not to be taken into account. They say that they say the need to persuade class members to join in opt-in proceedings is not by itself a good reason for choosing an opt-out approach. By contrast, they say, questions of how do you go about contacting this class, the fact that there's no industry body, they say whether opt-in proceedings are practicable, that point is relevant. So they're saying you don't. This is the distinction that my Lord Justice Green posed at the outset of this hearing between contactability and convertibility. And the tribunal here in my submission is saying it's not relevant for you to say that I might struggle to persuade these people to opt in. And so opt-in isn't practicable. It's perfectly relevant to you to say there's no industry body, I can't identify these people, I can't contact them. But where they are contactable, where they are identifiable, in my submission the tribunal is quite rightly saying that it's not relevant to say, well, you've got to expend resources trying to persuade them to opt in.
What did your submission ultimately boil down to in terms of convertibility? Is it irrelevant or relevant but of little weight? And take as your starting point that there is identifiability and contactability. So where you have that, what weight do you in your submissions attach to convertibility?
In my submission, in the particular circumstances of this case, it is not relevant. And the reason for that is that we have evidence both of contactability and a concrete ability to participate, because that's what's being contemplated at the distribution stage. So it's not the situation that one can legitimately point to the characteristics of this class and say there is some reason why contactability doesn't equate to convertibility because of the particular characteristics of this class. In my submission, that submission fails when one considers that that's exactly what the class representative is proposing to do at the distribution stage. One might, in other cases, have some reason why you can draw a distinction, but in my submission it doesn't arise here, precisely because at the distribution stage it's being positively advocated by the class representative that these people are able to participate and therefore there ought to be.
Speaking for myself, I find it difficult to place too much reliance on what's said by the tribunal in McLaren, because they were dealing with large business purchases, which by definition are a long way from the sort of individual consumers we're talking about here, and also no criticism, but the tribunal says we don't propose to deal with Miss Holloway's points in detail. Now, I know you're counsel in the case, so you can probably just tell us what those points were. But I mean, just looking at the face of the judgment, one just doesn't know exactly what the points were and how cogent they were in that case compared with the present case.
My lord, those points are entirely fair. I do say that the distinction the tribunal is drawing is a valid one, and I say it's one which must be right as a matter of principle, because otherwise you could have a less compelling claim, which will mean greater difficulty in persuading people to opt in. The less compelling the claim, the greater the difficulty. Apparently, the more strong your case would be for having an opt-out.
Well, it comes back to your point, which may, I see the force of, and may or may not be the really where this all goes to, which is that if one's focusing on convertibility, it might be said, well, that's always going to point to opt-out rather than opt-in, or at least in the majority of cases.
My lord, it will, and it also means that you're sending out the wrong incentives, because convertibility must depend in part on the attractiveness of the claim. And if you say that difficulties in convertibility point to opt-out, that means the less attractive the claim, the more likely you can justify opt-out proceedings. That can't be the right incentives to be sending it.
You say the less like the weaker the claim. I see that as a matter of logic. Strength applies at the opt-in stage under the rules, but not at certification. Inevitably, though, because of that, potential defendants are going to apply strikeout or a summary judgment. That seems to be the trend. So the tribunal will have to grapple with the merits, and it has to therefore conclude that the claim is realistic, beyond merely arguable, not fanciful. So provided you get over that threshold, question then becomes, what incremental value do the merits have? Well, if it's a follow-on and the liability has been resolved, that may be relevant. If you have a very, very strong regulatory intervention as background, that might have some, though lesser relevance. Beyond that, I'm not certain how much at this point really bites. It's hard to say this. If you've met the threshold, in a sense you've got the case to go forward. And the tribunal may not be in a position to really express much more of a view about the merits than that. So I'm not certain it's necessarily correct to say that the weaker the case, the more likely it is there's an opt-out, because the practice is there's going to be a challenge to the merits one way or another.
Your Lordship's quite right. What I'm seeking to grapple with is why, in my submission, it's not appropriate for convertibility to be a relevant factor to be taken into account. Once you have the ability to identify and contact the class. And I would commend to the court the distinction that's drawn by the tribunal in this case, in McLaren, that there is a relevant distinction between being able to contact them and then persuade them to opt in, and factors which might mean you can't contact them at all. In my submission, those factors, the inability to contact the class, does mean it's potentially impracticable for you to run an opt-in claim. But if you can contact them and persuade them to opt in,
Can I ask
But I think the problem with it, and that's why I raised the point with you, Ms Ford. As I read the whole of this passage in 166, what the tribunal is dealing with here is the need to persuade people, the need to persuade potential members of the class to join in, by reference to the strength or otherwise of the claim. That's why the tribunal say the preference the guide expresses for opt-in proceedings reflects the fact, generally a positive thing, for there to be a critical assessment of claims.
oh yes.
So in other words, what they're saying is it's no use saying, well, we're going to have terrible difficulty persuading these large business purchasers for this rather speculative claim that we've got, because that runs against precisely the point the tribunal are making. But we're not in that. This is not that territory. We're in completely different territory. We're in territory where, by definition, the tribunal has found that this is a good, arguable claim with a real prospect of success. So it's not a case where the class representative is saying, well, I'm going to have the devil's own job persuading any of these people to join in this class action because this collective proceeding, because it's a speculative claim. He's saying I would have difficulty getting them to join because of the nature of the class. So it's a different point.
My lord, that's entirely fair. It is a different reason why convertibility is claimed to be an obstacle. The answer in my submission is one must recognise that the class representative themselves are proposing the same steps at the distribution stage, precisely the same steps. And so, in my submission, if you can identify and contact claimants in those circumstances and you are expecting them to fill in a claim form and make a claim at some stage, it is not impractical to bring this claim as an opt-in.
We've probably badgered you enough for one morning, Mrs Ford. It's 1 o'clock. How much longer do you think you need?
My lord, I'm essentially finished with my ground one. I did have a brief point to address in relation to what's said in the skeleton about a factual question whether you can or can't identify the members of this class, but subject to that I'm finished with ground one, and then I think ground two I could deal with relatively quickly, and ground 3 I could deal with even more quickly because we've essentially canvassed the essence of it in the course of argument. So I would optimistically hope that could be done in half an hour if that meets with the court's approval.
What time could you sit? No problem sitting. Well, the court would not have a problem sitting on till 4:30 if
I'm very grateful.
that helps. After 4:30 we might start to get restless, but let's see how we go. So we'll say 2 o'clock.
Authorised?